Understanding bail and bond procedures in Oklahoma courts. I'm Appellate Attorney James Worth. That's the topic that we're covering, understanding how the bail and bond procedure works. So if you are arrested or someone is arrested for an offense, the officer makes a determination there's probable cause, they arrest you based on that, or there was an affidavit that was presented to a magistrate finding there's probable cause and arrest warrant was issued. In either case, at the time that that occurs, based on the crime that is being recommended by law enforcement or based on the crime that the magistrate has signed off on, it's going to determine what the initial bond amount is going to be based on bond schedules in the larger courts. So Oklahoma County, Tulsa County, they've got a list of a bail schedule list essentially that notes how much it's going to be for the type of offense that you're being accused of, and each one has a specific amount listed in there as the default to start with. However, not everyone starts with one. So for a particular offense like improper use of lane, it's got $100 on that. It's just a traffic ticket. For intimidating an officer, it's got $500. For intimidating of a witness, $2,000. It goes on like that. However, some of them have them listed as zero, and if it's listed as zero, that means that it is held without bail until a hearing can be had to make a specific determination for that matter. So for ones that are like that, it's the domestic, any kind of domestic offenses, it's going to be held, even if it's just a misdemeanor, assault and battery, domestic, that's going to be held until you can have a specific determination of bail. Act of terrorism, same sort of thing on that. So if there's an amount that's automatically set, then the person could contact a bail bondsman or pay that cash amount. So if it's set at $1,000, they can pay $1,000, boom, family member can help get that paid, and then they can be released with the promise that they're going to appear at the next court date. If they can't afford that amount, then they talked about getting with a bail bondsman, and then you pay a fee, normally 10% to the bail bondsman. Bail bondsman then can pay or makes a surety that they will take care of it if you fail to appear for court for the $1,000, and then that gets taken care of. However, if you don't have an initial bond set, then you have a specific determination of that. Or if you have a bond that's initially set by schedule and you don't like that amount, you can request an individualized hearing for that. You can file a motion to reduce that bail amount. And there are 7 particular factors that the courts look at when determining how much that should be. And all that information comes from a huge case in Oklahoma, Brill v. Gurich, 1998 OKCR 49, that then incorporates the Humphrey factors that were determined by the Oklahoma Court of Criminal Appeals back in 1979. And those factors have to do with the seriousness of the crime and the likelihood of conviction, the defendant's criminal history and record on previous bail, if any, his reputation, mental condition, length of time of residence in the community, family ties and relationships, employment status, identity of responsible members of the community that will vouch for him, and any other factors indicating the defendant's mode of life or ties to the community. So all of those factors are utilized together to help the court make a determination, but it's important to note that bail and being held for pretrial detention is not meant to be a punishment. It cannot be a punishment. It is meant to either protect the public if there's good reason to believe that the defendant is going to be a danger, and to ensure that the defendant appears for the court date. So if those two things are not an issue, then appropriate bail amount needs to be provided so the person can be out helping to participate with their defense. So that's essentially how the bail process and procedure works in the state of Oklahoma. It's set either automatically or individually if it's like a domestic offense or other offense that by the schedule requires that. You can request a reduction by filing a motion to reduce bond. You can pay the bail yourself, or you can hire a bail bondsman to do so. And everybody should be released if it conforms with community safety and that you are going to appear for your next court date. Those are the things that are the primary concern. It's not meant to be an amount of punishment. If you're dealing with this scenario, you probably want to talk to an attorney. Definitely if you're facing any kind of criminal charges, you want to do so. And you're going to want specific advice to your circumstances. To get that scheduled with an attorney at my office, you can go online to makelawEasy.com.